Okay. I think perhaps we should get going. Thank you very much for attending this session. We'll just have a momentary lull while we wait for Lillie Coney, the organizer, to return. So maybe 1 minute. Thank you. Well, I don't want to keep you waiting, so I think what I will do is mix up the order. I will start with the introduction of the panel. Lillie Coney has organized this. She will come in a minute. We have a little problem with name tags, which I think she's resolving. So this is an exercise, a hypothetical exercise, about a possible application of California law for a determination of accuracy, and I'll let Lillie describe that when she comes. To my left on the panel, I have Laura de Boel, who's an associate at Wilson, Sonsini, Goodrich, and Rosati. This is a global law firm with roots in Silicon Valley. She advises companies on all aspects of EU data protection law, including international data transfers. As many of the companies that the firm represents are located in California and offer services to the EU market, we have asked Laura to explain why a determination of adequacy for the California law might hypothetically be useful for such companies. Immediately beside Laura is Bruno Gencarelli, who... Leonardo. Oh, sorry. I beg your pardon, I've got my notes in the wrong order here. Leonardo Cervera, who has been working on data protection issues since 1999, first in the Data Protection Unit of the European Commission, and lately in the European Data Protection Supervisor's Office, where he works currently as head of unit in charge of human resources, budget, and administration. In 2007-2008, he was the visiting fellow at Duke University, North Carolina, and since there he has organized the first Data Privacy Day in the United States. While working for the Commission, Leonardo was in charge of the Secretariat of the Article 31 Committee of Directive 9546-EC and assisted with the drafting of the Safe Harbor Agreement and proposals on standard contractual clauses and binding corporate rules. In 2006, he was the recipient of the Barbara Wellebury Award, encouraging the development of pragmatic and practical approaches to privacy and managing cross-border data flows. And Leonardo's going to talk a little bit about various other instruments that could assist in making practical progress in terms of adequacy. Now, I'm going to have to introduce Mr. Gencarelli, even though he's not up at the panel, but he'll be here in a moment. He is the head of the Data Protection Unit within the European Commission, DG Justice. The unit's responsible for all aspects of the European Commission's policies and activities in the area of data protection, negotiation of the current reform of the EU data protection legislation, addressing the data protection issues at international, bilateral, multilateral level, including through the adoption of adequacy decisions, and negotiation of international agreements with third countries, such as the EU-US umbrella agreement. Also responsible for monitoring the implementation in member states of the EU legislation, including the Secretariat of the Article 29 Working Party, mainstreaming of data protection in all EU policies, and etc. He previously served as a member of the Commission's legal service and as an assistant or référendaire to a judge at the European Court of Justice after having practiced law in the private sector. He holds degrees in law and political science, and he's an associate professor in EU competition law at Sciences Po Paris. Mr. Gencarelli will explain how the European Commission regards the adequacy determinations. Now, beside him, we have Claire Gayrel, researcher at CRIDS, the Research Center in Information Law and Society at the University of Namur in Belgium. Claire had the occasion to collaborate with international experts on several adequacy reports for the European Commission. She's now part of the European project Paris, investigating the balance between privacy and security in surveillance systems. And I am Stephanie Perrin. I'm the moderator. My job will be to ask questions if you people don't. I'm currently a PhD candidate at the University of Toronto studying privacy issues in internet governance at ICANN. I recently retired from the Canadian government, where I worked on the Canadian private sector legislation for many years, including discussing its determination of adequacy with the EC. So, without further ado, Lillie, would you like to give us maybe 1 or 2 minutes on how this project arose?
Yes, I'd be happy to. Thanks to the panelists for participating in this discussion, and also for you for joining us in the audience, and also those who will be viewing this either live or later. As one who has focused on privacy law in the United States and spoken with many colleagues around the world about privacy protection within the United States, we've noted that a lot of you focus on the federal level, because in most governments, the federal level rules the privacy practices of their nation. Within the United States, we've often raised the issue of privacy protection on the state level, pointing out that privacy protection on the state level often is stronger than privacy protection on the federal level in the United States. And the leading state for privacy protection, in our view, domestically, is the state of California. And it sort of came as a thought after seeing Uruguay's process for adequacy being accepted by the EU, that if any state were to consider the possibility of achieving adequacy under our federal system, the state of California would likely, in my estimation, be the state with the greatest likelihood of being able to achieve that if possible. Now, this is an academic discussion. I'm not saying the state of California is in any way considering actually doing this. It would require federal collaboration cooperation, namely the State Department, the Department of Commerce, and likely the Federal Trade Commission, in working through any question of the state being able to pursue this. But it does have the resources. If it desired to do something like this, it would have the political will and likely the ability to achieve adequacy with the cost and the rigor that would have to go into an investigation of what the state currently does. Now, what I did was submit a list of questions based on the questions that were submitted to Uruguay in their consideration of adequacy to the state of California, asking that they answer each of the questions, and they did so. I have a cover letter from the Office of Director of Privacy, Education, and Policy, a statement from Joanne McNabb. It's very brief. She says, I am the Director of Privacy Education Policy in the Office of the Attorney General, California Department of Justice. In preparation for this conference session, I completed the survey of California privacy laws and enforcement mechanisms for the purpose of addressing the academic question of whether California could be considered to meet the adequacy standard under the rules of the Article 29 Data Protection Working Party of the European Commission. California has been widely acknowledged as a leader in privacy protection in the United States. Since 1999, and most recently in 2012, the prestigious Privacy Journal has ranked California as #1 among the 50 states and the federal government in protecting its citizens against invasions of privacy. Because its legislature passed a draft of a new protection in the last 2 years, also its courts and its constitution provide the strongest privacy protection in the nation of the United States. California's privacy statutes have served as models for other states and for the federal government. For example, the landmark 2003 law on data breach notification that originated in California has been copied by 46 other U.S. states, Washington, D.C., and the District of Columbia, the American Virgin Islands, and Puerto Rico. Similar regulations are also in place or under consideration in many other parts of the world, including the EU. And California's Attorney General's office dedicates more resources than any other state to enforcement of privacy laws. She said she is happy to contribute to this session and welcomes the opportunity to hear the analysis and opinions of the other panelists on this very interesting experiment. So thank you for this opportunity, and let's hear from the panelists.
Thanks very much, Lillie. If you don't mind, I think I'd like to hold the questions until the end because we are running a little bit late. So without further ado, over to Laura for her remarks on the companies.
Thank you, Stephanie. Hello, everyone. Thank you, Stephanie, for your introduction. We do represent many companies that are located in California and that offer their services to the EU market. And that will often involve the processing of personal data of EU citizens in California. So the topic of today's panel is highly relevant to us and to the companies that we represent. And I will give you an insight in what it would mean for businesses if California could potentially get such adequacy decision. But I think to understand what the implications would be for businesses, I think it's important to understand what currently the implications are for businesses of the prohibition in the EU Data Protection Directive on international data transfers to non-adequate countries. Because only so few countries so far have received an adequacy decision. And so many EU companies are finding themselves transferring personal data to non-adequate countries. And to overcome this prohibition, they need to adduce themselves adequate safeguards for the transfer. And so in practice, that will take the form of standard contractual clauses or binding corporate rules. And I just wanted to give you an idea of how burdensome that really is for companies. International data transfers are common practice, but implementing these mechanisms really has a cost and a burden related to them. And I think if you just take the example, for instance, of safe harbor, it seems like such a sensible solution for US companies. What a company needs to do for safe harbor certification is to review its practices, implement some policies and procedures to make sure that it can comply with the safe harbor principles, and then it can just do its certification online. And these principles are interpreted under US law, there's US enforcement, and so it seems like an interesting tool for US companies. But it's not a perfect solution because it's not, it was not established as a global data transfer solution. And there's a real risk of enforcement by the FTC with sanctions. Of course, as you all know, there's been some political tension over safe harbor, which creates, of course, some legal uncertainty for companies. And in general, there's just, of course, a cost and a time related to preparing for safe harbor certification. So if a company doesn't want to go for safe harbor, it can just implement standard contractual clauses. You have a lot of legal certainty there because they are prepared by the European Commission, and you can use them for global data transfers to any non-EEA country. But again, it's not a perfect solution, because if you have a large corporation, a lot of data flows, you would need to make sure that you have contracts in place for each of those data flows. And it can get tricky. And you would need to have some good contract management process in place in your company to just keep track of your contracts. Make sure that they remain up to date, because if your transfer changes, if your corporate structure changes, you would need to update your annexes to your contracts. And again, these contracts require some review of data processing practices of a company. They would need to implement some policies, procedures to make sure that they can actually comply with these obligations in the contracts. So again, it takes some time and it is costly. And then the third solution that is available to companies is the BCR, Binding Corporate Rules, which seems like such a good tool for groups of companies because it gives them one tailored solution for all their intra-group transfers. But it's not a perfect solution, again, because it only works for intra-group transfers. And your BCRs need to be approved by data protection authorities before you can rely on them. So it would mean that a company needs to engage in discussions with regulators about their compliance practices, which is not something that companies are very excited about. And also it just takes time. Implementing binding corporate rules can take up to a year, but it can take longer, depending on the type of company. And there's, of course, a cost related to that. So if you consider that international data transfers are just common practice, and companies are then required to implement one of these three mechanisms, that is, all of them are costly, burdensome, and not perfect. It, of course, seems like such a good solution to just go for adequacy. And there are countries that are trying to get on the list of adequate countries. For instance, Quebec, the province of Quebec is trying to get adequacy, but some countries have also failed in their attempts to get an adequacy decision, even though they have privacy laws, like Australia. But of course, it would mean a free flow of data to their country or states. It would mean a lot less administrative burden and cost for the companies involved, and it would be an economic incentive for the adequate country, for the importing country. So if we then look at the state of California, as I said, a lot of the most innovative solutions, most innovative services that involve the processing of personal data of EU citizens are offered from California. That's also just a reality. And why wouldn't California be considered adequate? If you look at privacy laws in California, they're actually quite strict. There's a Californian right to privacy in the Constitution, in the Californian Constitution. There's a whole set of laws that regulate various issues, going from online privacy to direct marketing. And there's strict data security requirements, like the data security breach notification obligation. So clearly the approach that's taken to privacy in California is not the same as the approach taken in the EU. It's not the same mindset. But that doesn't necessarily mean that the level of protection is inferior. I do see some practical issues. For instance, what about onward transfers? That doesn't seem to be restricted in California, but you couldn't have data going from the EU to California under an adequacy decision and then flowing freely to another state in the US that's not adequate. So I think that's something that would need to be looked at. Also, as in any federal country, I think there could be an issue with the level that is competent. What if the state would be adequate, but there would be some privacy regulation at the federal level? I think that's also something that can raise a problem. But I think in any event, it really would be recommended for the EU to take into account the fact that so many third countries have privacy laws. An importer of EU data will often be subject to privacy restrictions in the home country. And that's something that is not taken into account today in EU data protection law. But to end on a positive note, if you look at the draft General Data Protection Regulation, it does have some interesting changes to adequacy findings because it provides explicitly for the possibility to get adequacy decisions for territories or specific sectors in a third country. So on that note, over to you.
Thanks. Thanks very much, Laura. That was very thought-provoking. Now, if we could, I'd like to move to Bruno Gencarelli for his views on this.
Thank you very much. And thank you very much for the invitation. As the representative of the Commission, I feel as the adequacy man today. And unfortunately, I'm not always bringing good news. But I take this as an academic discussion, and I take it as such, and I will try to explain briefly what adequacy is and what adequacy is not. Adequacy is certainly a very detailed, comprehensive, if not intrusive exercise into the laws, the practices, the institutional setting of a foreign entity, foreign country or a region, a specific sector. As was rightly said, we have already had partial adequacy decision, and now it's specifically provided in our proposed regulation and has been confirmed both by Council and Parliament that partial adequacy are a possible way to go. It's also a process that may take some time, that may require the candidate entity to amend its laws, as we have seen with New Zealand, for instance. But there's a reason for this complexity, for this possible length, for this almost intrusiveness. because when adopting an adequacy decision, when making an adequacy finding, the Commission extends a benefit which is in principle reserved to member states. I think data protection is one of the very few areas, if not the only area in EU law, where we can extend to a foreign country, a foreign entity, something which is provided under our legislation and applies to our member states, i.e. the free flow of data. An adequacy decision, for instance, if we were to adopt an adequate, and we all love California, that's needless to say, but if we were to adopt an adequacy decision vis-à-vis California, it would mean in practice that a flow of data between Belgium and California would be treated exactly as a flow of data between Belgium and Germany, for instance. Therefore, you can easily imagine that before extending such a benefit, we need to be very careful, and we need to check a number of things, also because we are under constitutional obligation. As you know, in our system, which is different, for instance, for what is the case in the United States, at least at federal level, but privacy or data protection is a fundamental right that requires a number of protection, and one of the protection is the continuity of protection when data is transferred abroad. And what does adequacy involve in terms of what is the type of assessment we are making, what is the type of checklist we are looking at? When we have to assess whether a foreign regime can be considered as adequate, we take a wide variety of substantive and procedural factors into account, relating both to the specific data protection rules of that entity, as well as to the broader legal and judicial architecture of the third country, of the foreign regime in question. And this is essentially the Commission assesses whether the third country legal framework provides for a number of what we call content principle, meaning principle of substance, substantial protection, namely principles that are well known, such as purpose limitation, data quality and proportionality, transparency, security, rights, individual rights of access, rectification and opposition, restriction on onward transfer, and I will come back to that, additional safeguards for sensitive data or special categories, as you call them in the United States, direct marketing opt-outs, provision on automated individual decision, etc., etc. That's for the substantial part of the assessment. And then we also look, and this is extremely important, on how the rules are enforced, including whether, and that's also an important issue here, whether there's an independent supervisory authority responsible for ensuring compliance with data protection rules, whether there are effective redress mechanisms and remedies available to individuals, including to EU individuals. The access to courts or of EU individuals to foreign courts so that EU data subjects can invoke those rights, in particular the rights to access, redress, and rectification, is an extremely important issue. For instance, in the adequacy process we had with New Zealand, that access was only reserved to citizens and permanent residents of New Zealand, and New Zealand had to amend its law to be considered adequate. As we know, access to courts in the privacy field in the United States is a particularly sensitive issue, not so much for the commercial sector, but in the law enforcement sector, because the Federal Privacy Act contains some limitation in that case. And that's a very important point, the supervisory or the institutional aspect, because the idea behind that is that given that we are talking about a fundamental right, the system has to provide support and help the individual data subject in the exercise of their rights. The individual must be able to enforce his or her privacy rights rapidly and effectively and without prohibitive cost. And to achieve that, there must be some institutional mechanism allowing independent oversight, independent investigation, in particular of complaints coming from individuals. And therefore we are, in other words, adequacy is, as I said, it's a complex, comprehensive, rather intrusive assessment of a foreign regime, which looks not only at law in the books, but also at law in action. And this means, in particular, how data protection safeguards are enforced and are enforceable by individuals. I'm not going to dive into the intricacies of the adequacy process in terms of decision-making process itself, but just to remind that the adequacy is not an international agreement. The adequacy is a finding made by the Commission, by the College of Commissioners, so that's how we adopt a decision in the Commission. So if you want a unilateral decision by which the Commission decides that a foreign regime provides a number of safeguards. But although it's an individual decision by the Commission, it also involves other institutions, because before reaching that point in which the services of the Commission propose to the Commissioners to take that decision, we need to get an opinion by the Member State data protection authorities in the framework of the so-called Article 29 Working Party. And while this opinion is formally not legally binding on the Commission, of course it carries a very important weight, given that it is issued by the independent data protection authorities of our Member States. And we have seen in the past that before giving that opinion, the Article 29 Working Party can enter into its own dialogue with the foreign country, asking about more information on the substantive rules, on the on also the procedural aspects, on the case law, asking also for sometimes very detailed questions on specific cases, on specific investigations, etc. So we need an opinion, and a positive opinion if possible, by our national data protection authorities. We need also an approval by our member states. We have what we call in the EU law framework a comitology procedure, which means, in a few words, that before doing something, the Commission, fortunately or fortunately, needs the green light of a representative of its member states, and we need a positive opinion of a committee composed of representatives of our member states. Then you have the adoption by the college, and even that adoption is on the scrutiny of the European Parliament, that can ask the Commission to mandate, amend, or withdraw its decision in certain cases. And this process may take some time. It takes at least 2 years between the moment in which there's, if you want, an application. There's no formal application, but when there's a strong signal from the member state, from the third country or the entity of an interest to the adoption, and it often takes more time because there's a dialogue with that third country or that foreign entity, and there's often a need also for that foreign entity to change and to amend its own laws. But I also want to, after having said what adequacy is, I also want to say very shortly what adequacy is not. Adequacy, although we have this important list of criteria, and I explain why we need to do that assessment, adequacy doesn't mean identical. Adequacy doesn't mean that we are looking for a photocopy of the EU regime. Adequacy means that, in essence, what matters is that the foreign system in question delivers a similar level of data protection from a substantial point of view, taking into account, of course, that we are dealing with different legal systems in the world, and even if you look at our adequate countries, from a more continental system as Uruguay to a more common law system as New Zealand, we are covering a broad range of legal systems. We are also taking into account that many systems are, of course, free to organize themselves on the basis of different institutional mechanisms. But again, we are not looking for photocopy, but we are looking for a similar and identical level of protection. And as was already said, it is not necessary that the third country or the foreign system is considered adequate in its entirety as a whole. We have already accepted what we call partial adequacy that are either limited to a certain geographical region, that's particularly interesting for federal state, or a particular sector of the economic processing sector. And actually the safe harbor, that was mentioned, the safe harbor is nothing else than a partial adequacy decision. And I know I have to come to a conclusion. There will be no conclusion, but maybe against the background of the elements I've just provided, I just want to list issues that in our recent experience with adequacy decision have been of some relevance, and that may be of some relevance in the case of California. And this is far from being an exhaustive list, of course. As I already mentioned, access to court. They need to ensure that EU data subject have an access to court on equal footing with the citizens or residents of that country, of that foreign regime. That's absolutely, it's a necessity. Also because in our system, in the EU, we don't make any type of distinction based on nationality, citizenship, or residence. Another very important aspect is the administrative redress. The EU approach to data protection, as I said, is based on a two-tier approach where you have administrative redress and judicial redress. Therefore, the existence of an independent, and we can then discuss how independence has been defined, but an independent oversight body is also absolutely required. Another aspect is on-one transfer. On-one transfer is having clear rules on on-one transfer is of course important, because when we recognize that the foreign regime is adequate, it's also very important, and we check on that, that there are no loopholes or black holes, a possibility to circumvent rules by just further transferring the data once it has been transferred to that entity. And then, of course, and that would be really my last point, and then, of course, and that has become more and more important in light of recent developments, the question of access to data by public authorities. What are the limitations in place to ensure that the principle of necessity and proportionality, you call them differently in the United States, but you have very similar concepts in terms of targeting, in terms of tailoring, etc. What limitation, what safeguards are in place to ensure that when public authorities have to access data for national security purpose, for law enforcement purpose, that access is limited and is not massive and undiscriminated. We could have, I guess, a whole afternoon just on that list of issues. I need, I guess, to end now. Of course, I'm very happy to answer any question. Thank you very much.
Thank you very much. And that is indeed a great list that you have there at the end. I'm sure there are people taking notes and being ready for questions. Now, perhaps if we could pass over to Leonardo there to make his presentation. Thank you.
Okay. Thank you very much to the organizers for inviting me to this very interesting panel, and thank you very much to the audience for being here, and thank you very much to my colleague Rasa, who is in the audience, who has helped me a lot to prepare the little bit of research for this talk. Let me just say 20 seconds where I come from. I work for the European Data Protection Supervisor. For European audience, everybody knows who the European Data Protection Supervisor is, but perhaps for some foreigners it's necessary to say we are the Data Protection Authority of the EU institutions, which is not the same as the EU Data Protection Authority. There's a slight difference there. So we supervise the processing of personal data by EU institutions and bodies, but at the same time we provide advice to the legislative process in the EU. Every time there is a legislation being proposed with data protection implications, the EDPS is consulted and provides constructive advice. And we are closely involved in international cooperation, not only with our national data protection authorities, but also with third countries. And we try to play some leadership role in the area of data protection from the regulator point of view. Mr. Buttarelli, our new elected supervisor, will tell you tomorrow what is his vision about all these issues. Now, let me say that I have accepted this invitation not because of my knowledge on US law or California law, because clearly there are other panelists who know much more than I know, or not because of the relevance of the EDPS in any adequacy finding, because this finding corresponds 100% to the Commission. So the EDPS, if there was an adequacy finding, would be, of course, consulted, but the decision legally, politically, corresponds entirely to the Commission. But what I can bring to this is a very long experience dealing with adequacy findings in a time when there was a very interesting dialogue going on between Europe and the United States. I participated in the Safe Harbor Agreement. I drafted the standard contractual clauses. With a group of DPAs, we invented binding corporate rules. And I was given a prize in a given moment for finding an international data protection prize for finding pragmatic solutions to the transfer of data around the world. So from this perspective, if ever I can be helpful, I am available to help in an academic position. Now, what is the three things I would like to say, because most of it has already been said by Bruno in a brilliant and quite exhaustive way, because in the few minutes he was given, he really put the basic about adequacy. What I would like to say is that even if this is a theoretical exercise, I think the situation of data protection in the state of California has to be treated seriously. Because from the survey, we can see that data protection is serious business for this state in the United States. Certainly, much more serious than for other parts of the country, and indeed, much more serious than for many countries around the world. So that, I think we should recognize is in the constitution of the state, and there is an impressive list of sectoral legislation that deal with data protection, not in the way, perfect way we would like to be, but nevertheless, we have to recognize that there is positive elements there. There is also an attorney general who is not a data protection authority. It falls short for some of the criteria, but nevertheless is entrusted to protect a constitutional right. And this is also positive. So now, the shortcomings have been very well described by Bruno on the basis of a very long experience by the Commission doing this analysis. And I would just stress three, which have been already mentioned, but in my view, from my experience, are the most relevant. First is that it is not acceptable that EU citizens cannot, in a given circumstances, have the same rights that citizens in California. That's a clear border, a clear line. I mean, EU citizens would need to be treated in the same way. Otherwise, it's impossible to consider adequacy. Second, the issue of onward transfers. If data goes to California, and then from then it can go everywhere else in the world without any protection, the system is flawed, so it cannot be considered adequate. And the third point is a little bit more political, as Bruno clearly said, is the relationship between the state and surveillance, is the relation between the state and access of intelligence and security bodies to the access of European citizens. So for us, this is quite important. It's a fundamental right. So even if these matters are clearly a matter of sovereignty of the state, indeed, the state could do whatever they want, but if it has an impact on data protection, an adequacy finding could not be granted. Now, does it mean that with these big gaps we should not consider this matter? Certainly not. I remember very well when we started the negotiations with the states for the safe harbor, everybody said, really almost everybody said, you're crazy, you will never manage to find a solution to the big problems that we have in front of us. We are too far away one from each other. And we did manage to find a solution. Imperfect solution, always some valid criticisms about it, but there was a solution. And I think we made progress, and we both benefited from the Safe Harbor Agreement. But of course, it was only possible because there was a real political will in both European and American administration to do something. And it was done. So I would not consider this just a purely hypothetical or theoretical debate. There could be some merit to look into this. And the last point I would like to do is, and this is addressed to colleagues who are working on these matters in California or in the States, is that we think that it's a very smart move from you to consider data protection so seriously. Not only because data protection is becoming essential for any technological development, but also because it shows a leadership in a field that clearly in the United States is now taking some momentum after the announcement made by President Obama. So for those who are working on these issues, well, I can only say a smart move, keep on working, and if ever you need any support in terms of finding pragmatic solutions and things like that, I'm available to give a hand and to share with you my personal experiences when we were discussing with the States. Thank you.
Thanks very much. I might take you up on that as I try to figure out why ICANN is missing privacy protection. But that's a whole other topic and another afternoon. So on that note, thank you very much for that contribution. Over now to Claire Gayrel.
Yes. Good morning, everyone. I'm Claire Gayrel. I'm a researcher at the university here in Belgium, in Namur, in a research center in information society and law. So I'm from the academic world. I'm independent. I don't speak for the European Commission or anybody else. But actually, I follow the European Commission opinion. But it is not because many things that have been explained by Bruno, I share completely this view. But this is not because I speak obviously in the name of the European Commission. I had the occasion to collaborate on several adequacy studies. I'm a baby in this world compared to my colleagues, but it's a passionating exercise, very passionating exercise. And the invitation to think about this hypothesis of California as adequate is a little bit funny, of course, because I think it was a very good idea. And this has been said, nothing prevents, I think, a state within a federation to apply for adequacy. Quebec has been the object of a recent opinion delivered by the European Working Party 29. So there is a signal that it is not a complete obstacle to be a state. A word about the methodology, because I have been involved only in a very, very early stage. You know, we, as a university, as independent researcher, we provided some analysis, and then we don't know what goes on further within the Working Party 29, further political negotiations. We are not part of that. We are just part of a very initial and independent assessment. And maybe it's very early beginning of the process, you know, and I have tried, in my experience, to be as neutral and objective as possible, without prejudice, considering the continent, the type of system, common law system or not, etc. Of course, I have tried to be as objective as possible, but this is not always easy. And it's a quite long work, just to say that it requires several months, involvement of local experts, European experts, quite a lot of discussions, sometimes interviews on the field to really understand. It's also an approach of a world culture that an adequacy assessment involves. That's why it's also a passionate work. Having said that, now I have some reactions, of course, about the Californian system. Of course, the primary thing I would look for if I had to do an assessment is there a constitutional protection of a satisfactory constitutional protection of fundamental rights? And this is a case in the Californian system, and this is a very strong and very positive factor. It is a prerequisite. In my experience, it is very difficult to reach any adequacy finding in relation to data protection only. Data protection has to be in the one element in the whole picture of protection of fundamental rights. And I can give very, very concrete examples, because some countries are adopting data protection legislation without having comprehensive privacy protection, yet even mature privacy protection legislation. This is not the case for California, but this is something that I have encountered in considering other countries. And if you, and case law, analysis of the whole constitutional case law is very, very interesting, because if you do not have private life protected, sex life, all these aspects, more general aspects that are not directly related to data protection in general, all the benefits of the protection of private life is not translated into data protection legislation. So you won't find, for example, a definition of sensitive data, including protection of data relating to sex life, when such, of course, aspect of privacy is not protected under the right to privacy and private life, for example. So there are very strong connection, of course, between the right to privacy and the right to data protection. This is only one example how they are related in practice. And so this is obvious. In the case of California, it is a very positive factor. Immediately you say, okay, there is a protection of privacy, this is very good. But then, as it has been mentioned, there are lots of regulations, but it's also part of the problem, that it's a sectoral approach. And although the Article 25 of the directive includes analysis of sectoral legislations and refers to sectoral legislations, I believe, as an independent expert in practice, that it is not possible to reach an it is very difficult, at least, to reach an adequacy finding without a general data protection legislation having a quite wide scope of application, at least with respect to the whole private sector. So when you don't have such legislation, as an expert, it would mean that I would have to look at all the loopholes of protection and try to identify what is not covered. And this is a very difficult task, in a way. I can see what is covered, but it's more difficult sometimes to see what is not covered. And I have to do this speculative exercise, and it is very, very difficult. So I think globally, a sectoral approach is not very compatible with the EU adequacy policy. Some more specific reactions, all the other members of the panels have underlined the same points, and I think this expresses that this is really the core issues, and which are scope of protection granted or not to foreigners, and in the case of California, the most important laws, Shine the Light Law or the data breach notifications, etc., they are limited to Californian residents. And so this kind of limitation, it has been said, is not compatible with the EU approach. It is really an unavoidable issue. The second one is related to onward transfers, and here I would like to add something, because maybe it's, even if California adopts restrictions to onward transfers, that even if they would be willing to adopt such restrictions, the question, I think, is on the part of the US. Are such restrictions compatible with US law? And as it has been said, this is why it is more a US question even than an EU question. I'm not sure, I don't know enough, but I guess this might not be acceptable for the US, you know? So here there is a big problem. I have also seen that the privacy office is not founded anymore, so there must be very effective enforcement mechanisms. And in particular, in relation to a state having a sectoral approach. I was thinking about that, saying myself, no, I don't see it as compatible with EU policy. But in the same time, I thought, okay, only if very, very, very effective enforcement mechanisms are in place, this might be possible to envisage adequacy with respect to a country having a sectoral approach. But I think in that case you would need to demonstrate very, very high level of compliance with the rules and enforcement mechanisms. And the third issue is related to governmental access to private data, and after Snowden's revelations, I mean, it is impossible, I think, to avoid this question. And the European Commission and the member states have not been willing to waive the safe harbor, while there are some provisions addressing this issue, and for political reasons, economic reasons mainly. But I think that if the safe harbor has been adopted prior to Snowden's revelation, now that we know, it is complicated to put aside these revelations and not to take them into account in an adequacy assessment regarding California. And my conclusion is that, in my experience, it really follows what Bruno said, is that being considered adequate means becoming a member state of the European Information Society. It's really, as I see it as well, because you liberalize completely the flows of data. And so I came to this conclusion that that's why it's intrusive, because becoming a member state of the European Union, it requires a lot of intrusion into a third state. And so it's a little bit the same, limited to the digital market, information society issues, but it has something similar with the policy of enlargement. And so that's why it requires a lot of commonalities, and as he said, a similar system, at least identical protection. And that's why California presently has very, very strong loopholes of protection. I didn't analyze everything, I had only 2 weeks, but in few hours I could identify some obstacles that are just, you know, unavoidable. And so, because it was an exercise to give some opinion, of course, even if it's not, I couldn't do a complete analysis, California is not adequate. This is my conclusion.
Well, thank you very much, and that ought to stimulate some questions. Thank you very much for raising one of my favorite issues, namely metrics and how to measure budgets and compliance. Questions from the floor? Yes.
I would suggest that you start with the gentleman right here.
Ed Hasbrook,
yeah, he is very knowledgeable of California law, and of course the state of the privacy office has been absorbed into the Attorney General's office, so it is continuing to be funded. But I'd like to hear what Ed has to say in reaction.
Thank you very much, Lillie, and all of you. Unfortunately, as a Californian, this is of more than academic interest to me. I think I'd be remiss not to make clear that Californians and Americans want the European Commission to recognize that the safe harbor finding was wrong and revoke it as soon as possible. Safe harbor is not adequate, it's failed, please withdraw it. But I would also want to point out two other major inadequacies to California law that have not yet been mentioned. One is that while California has some privacy laws, it has no data protection laws. There is no subject access right with respect to commercial data in California law or the law of any other US state. And subject access rights are a crucial piece that's not privacy, but is part of data protection. I suspect that if California enacted subject access rights, most of the major IT companies would move their legal domicile out of California to some other more sympathetic state, but there certainly is no pretense of subject access rights in California law. The second area is federal preemption, that there are entire industry sectors over which California's Attorney General and California law has no jurisdiction. For example, all personal data and other consumer issues related to common carriers, including airlines, including processing of PNR data, are under exclusive federal jurisdiction. California's Attorney General has twice joined more than 40 of his state Attorney General colleagues in urging the US Congress to end that federal preemption of the airline industry and allow states to exercise control and protect their citizens in that area. Congress has declined to act. And if you think you could have a sector-specific adequacy decision, how do you parse out a company or a business that holds data from multiple sectors? For example, Google has a division which processes PNR data on behalf of airlines. That division is not subject to California jurisdiction. It's not even subject to FTC jurisdiction. It's under the exclusive jurisdiction of the US Department of Transportation, which has no competency in privacy or data protection and has completely ignored it. Would Google be required to firewall that division if there was a sector-specific adequacy decision that was of necessity excluded those industry sectors where there's federal preemption? So this whole question of federal preemption would also need to be addressed in some way.
Thank you, Ed.
Okay, Tobias Morsches from Datenschutzraum, Germany. I'm not a lawyer, and I just read a lot of stuff about such things, and one of the great achievements of the US Constitution was the decision to differentiate between people and citizens. And I have read a lot about lawyers who said, yes, the Constitution applies also to people everywhere, but it's very difficult to enforce their rights and to do something about this. But my question is, how realistic is it for California or the US to follow the spirit of the Constitution, to take the people everywhere to certain rights and to give these definition of people teeth so that they can access their rights?
Did you have someone in particular you wanted to answer that, or could we throw it open?
Yeah, I was just gonna. One, I wanted to thank you for that question. For a long time, the position of those who are in elected office and just a general statement of policy of the United States pre-fall of the wall was that democracy belonged to people as a human right. The wall came down, and then a lot of that language about privacy, about democracy, sort of became muted. And it would be very good to see more strong language about what democracy means, that it is a human right, that it extends beyond the shores of a nation to some fundamental freedoms, the 4 freedoms that were talked about the principles that organize nations to come up with ways to deal with conflict among themselves in a more peaceful way. Now we're getting into the reason I brought this issue up is because of the economic implications of adequacy, and that being a vehicle for introducing some of these discussions back into mainstream. Some considerations for what it would take, what the benefits are to the state, looking at a state with the resources and the political clout to actually pursue this. And then, of course, the real consideration that a state alone couldn't do it. They would have to have, from this discussion, the Department of Commerce, the Department of State, the Department of Justice, likely the Federal Trade Commission, as partners in developing a dialogue along the lines of what it would take in order to be considered for adequacy, along with the changes in the law and how individuals would be treated. Which would be huge steps forward. Now, states like California have been willing to treat non-citizens with the same constitutional rights as citizens of the state, which is also helpful in this dialogue. But then there are also some of the things that Ed raised with preemption, federal government willing to allow a state to have this area where these laws would apply, and having laws apply in other states and not apply in one state, that won't fly. It would generally affect all states, and the area of preemption has been pursued very aggressively over the last 10, 15 years. It would be nice to see a reversal on that. So I think this is a good dialogue to have.
I wonder if we could ask Mr. Gencarelli to respond to that question as well. And may I throw in one of my own? I'm wondering about the limits of what you can provide in contract law, but either through the binding corporate rules or even through safe harbor, as opposed to passing a law, having it ensconced in the Constitution.
That's a lot of questions.
Yes.
So I'm going to try to react to some of the things I've heard. First, this question of, if you want, non-discrimination or access on an equal footing to courts to redress it. It's true, it's an important issue, but I think there are good signs and positive signs and signals that we have come to a period where there's been a realization that that needs to be addressed, that in a globalized world, those type, especially when you are talking about data flows, those type of distinction don't make much sense, also for all sorts of reasons, because of the commercial, economic increased relevance of data, because of the importance of data flows for law enforcement cooperation, for all sorts of reasons, especially with the United States, we have entered a much more dynamic phase of dialogue on these issues. Yes, we love California, but we love lunch too. So, as you know, that's at federal level, and it's on a very limited piece of legislation, which is the 1974 Privacy Act. But Attorney General Holder has announced in June that he would, the administration would work to try to get from Congress some legislation extending the judicial route. I know that some people in this room maybe, and some people outside of this room might think that this is symbolical, this is almost charismatic, that this doesn't have but this has been a request from the EU for 10 years. For 10 years. And for a long time, there was not even an acknowledgement from the US side that that was a valid demand and request. And so getting that sign from the US administration, getting that sign now from Congress, because things are moving, is a very important signal, and I think sets a very important precedent. Second thing, we thought, meaning, certainly not an expert of Californian law, I'm not an expert of US federal law, but this question of preemption, of course, gives even, federal preemption gives even more relevance to what we have said about on-one transfers, and the necessity to, if there would be, to fence or to ring fence a certain sector. And I guess that if you have this issue, that's the complexity of federal system. If you have this issue where, if you have a situation where, and again, it's an academic exercise, where you have a federal, a state which is considered adequate, or why the federal system is not considered adequate, then you would have to consider those transfers from state to federal as on-one transfer with a certain number of protection, I guess. Then on the issues of, I like very much what you said about the cost and benefits of adequacy. What we always say to countries or systems which are interested in adequacy is that this is a purely legit and in a legitimate way a sovereign decision to be taken by the system, whether it makes sense, whether it is commercially, politically sound to seek adequacy. Adequacy has a number of benefits, of course, and I totally agree. Adequacy means accession to the EU as far as data protection is concerned. It has, of course, it gives a seal of approval that can be of a strategic competitive advantage for the company and for the digital economy of that system, but it has also a number of costs, as it often involves a substantial strengthening of the level of protection and thus considerable adaptation costs for data controllers and processors of that system, including those which are, including the controllers and processors of that foreign system, which are not or marginally importing data from the EU and which may have therefore not so much interest in that process. Issue of California is of course different because California is from an IT point of view as even an economic power and for the importance of the relationship from the EU has a large part of its economy, I guess, importing data from the EU, but still it's a question to be answered. And on that, I just want to add, because I've heard a bit kind of a more negative picture about rules on transfers, but adequacy is only one of the tools in the toolbox. I understand that that's true, that the other tools that are the toolbox, BCR, contractual clause, etc., don't present the immediate and the same benefit of adequacy, but it's also important to understand that in the context of the ongoing reform, we are enormously facilitating the use of alternative tools such as BCR, such as standard contractual clause, by abolishing a number of administrative hurdles in terms of pre-notification, pre-authorization, this situation which is completely unsatisfactory today, that certain DPAs in certain of our member states ask even sometimes individual notification authorization to use this instrument. Now that will be completely changed with the regulation, because you will have a sort of one-stop shop EU blessing of those tools, and no national authorities in the EU will be authorized even to ask for notification of authorization. So I think that actually, and that has been confirmed by the Council last June, and what we're doing will facilitate the use also of other tools than adequacy.
Thanks very much. I don't want to cut off the audience. Oh, maybe we better let Stuart Dresner ask his question.
Canada. Sorry, thank you. I'm just saying, Stuart Dresner from Privacy Laws and Business. My company carried out many of these adequacy studies before CRID, and found many part of the process. And so we were able to point out various weaknesses. But anyway, the point I want to get to now is on the question of adequacy of the current countries. The question is, it is on negotiations on the EU data, the regulation, the draft regulation, there's been a discussion of whether the European Commission would go back to the current countries declared adequate, Canada, New Zealand, and so on, after a certain number of years. Obviously, those countries would like to remain with the adequate status. What is happening on the negotiation on this point? Because it is sometimes said some countries are weaker than others. Maybe in practice, California is stronger in some respects than some of the countries which already have adequacy status. So what's happening on the negotiation on this point?
Two things on that. The position of the Commission is very clear, as it expresses in its proposal, a continuity of adequacy decision for question of legal certainty. So the countries that have been considered adequate under the current directive of 95 will continue to be considered adequate under the new regime. That said, in each and every adequacy decision, the Commission is granted the power to review and even possibly even suspend and withdraw adequacy decision, because foreign systems can change, laws can change. And that's actually, it's on the basis of that possibility that we are now reviewing the safe harbor. We have identified, as you know, a number of, let's call it, shortcomings, deficiencies of the safe harbor, and we have established a list. Some people think that that list is too long, some people think that that list is too short, of 13 points on which the safe harbor needs absolutely to be strengthened. That's meaning that's how we proceed. When we see problems, when we are informed about problems, we intervene in that way. It's also true that in each and every adequacy decision, DPAs are granted a power to suspend specific data flows when they consider that the foreign system doesn't offer any longer the appropriate safeguards. And I wanted, maybe we will close, and maybe as far as I'm concerned, draw your attention to a pending case before the Court of Justice, Mark Schrems versus Facebook, reference for preliminary ruling coming from a court in Dublin. And as we know, most of the developments in EU law comes from reference for preliminary ruling, asking exactly that. What are the powers of DPAs to suspend data flows to adequate country, in this case under the safe harbor, to the US, on the basis of the revelation on mass surveillance. Very important case that probably we will have a judgment at the end of this year, beginning of next year. Let me also say, we have of course talked about the differences, what may be some points on which we might have a slightly or less slightly difference of approach with California, but what we see is more convergence than divergence. The global trends are going towards horizontal, comprehensive data protection legislation, strong and oversight authorities. We see new laws in Japan. We see a new law that has even a new constitutional provision that has been adopted last year in Mexico, recognizing that data protection is a fundamental right, and that, as we know, has a number of consequences, strengthening their oversight authority, not only in the commercial sector, but also in the public and therefore law enforcement sector. And those are just two examples. And again, I think that that's a response to, yes, fundamental rights needs, but also to the enormous and increasingly relevance of personal data. As I say, compare maybe to the situation you had 10 or 15 years ago, and you were very creative and brave in facing such a situation. We are now in a world that goes more where we see commonalities rather than divergence. Maybe not enough, but it's encouraging for us.
Thank you very much. I'm standing between you and lunch, but I would like to give the panelists that have not had an opportunity to respond at least 1 minute each to make a concluding remark.
Well, for me, for the business perspective, I think, like I said, so many third countries have privacy laws, and that is not taken into consideration in any way under EU data protection law, and I think that might need to be changed.
Yes, I wanted to react about the absence of access rights. And this is true, I was wondering, but as I couldn't check all laws, I didn't want to raise this issue because I thought maybe somewhere there is something. But I was, I noticed that, and I thought, okay, here there is, I think there is a very strong problem. And I only looked for the civil code and customer records, etc. I couldn't find, and I found it, yeah. this is also another very, very important divergence. Yeah. Thank you.